there and taps his hands and you're just sitting there and he, sits there and rocks back and forth in the chair like a bit of another murderer or whatever he is, convicted. Up to this point of a case, not in handcuffs, not in shackles, one or the other, or both, and in orange.
Hello, everybody. Excited utterance here. My name's Hella. It's another Brian Kohberger stream. Can you guys hear me okay? Just testing, because I couldn't hear that intro, but I could hear it on YouTube. So I'm pretty sure it was working okay. Let me know. Everything cool? Give me a thumbs up. Sweet. Thank you very much. Hello, Lois Cox. Nice to have you here. I think it's the first time I've had you here. Welcome. Yes, it was a very short hearing the other day. It was only about 13 minutes or so, but some things were achieved. There was a trial date set. I am iffy as to whether or not that actually is going to go ahead, and I have my reasons for that. We'll talk about that today. We're also going to have a little bit of a talk about the previous things that have been happening over the last month or so in regard to the Kohberger case. I have some thoughts as to whether or not the alibi is going to stand up. And I know that some people have been mocking the alibi, saying, oh, it's not a real alibi. He driving around, stargazing, etc. That doesn't sound like an alibi to me. But it doesn't really matter what he was doing. It matters whether or not he was somewhere else. And I tell you what, this expert witness, Cy Ray, he has some credentials about him. He really, really does. And his appearance in court a few weeks earlier, when he was at that hearing, it was pretty embarrassing for the state. He was actually commenting on whether or not the state witnesses who had been called previously, so Detective Payne and Detective Mowry, were even competent to use the software that they had put forth in the exhibits to generate the maps, which showed that Kohberger had been driving around near the house after the crime, the time of the crime, as per the PCA, the probable cause affidavit. So that's really embarrassing for the state, because Siren actually wrote the software and he is a trainer for the government. And if you have been watching the Karen Reid trial or the Chad Daybell trial recently, you would have seen a lot of maps with a big Trax logo on it, TRAX, Trax. And the Trax logo is his software. He wrote that software. And he is a trainer for the government now. He worked for he was a policeman, he was a detective, and his specialty is digital forensics. So he then left the police force. I think it was 2014. He left the police force and he started his own company. And can't remember what the original name of the company was, but now he has a company called ZX. And he wrote this software called Trax. Now, Trax is being used by the FBI and by law enforcement, by police all over the country, and it's being entered into evidence in trials all over the country. And he is a trainer because he wrote it. He wrote this software. So he is the expert in cell tower data analysis. And he has never, ever before this testified for the defense. Yet he's testifying for Brian Kohberger. And the very first time he got up at the hearing, this is on the end of May, so not this last hearing, but the end of May, he got up and he said, listen, what I've seen of this data so far is exculpatory, but I haven't seen everything, and I withhold judgment. Now, there have been 6 motions to compel by the defense. 6 motions to compel. That's a lot. And this has been going on since January 2023. That's a long time. Now, if and when the state comes forth with the rest of the information, and he's spelled out very clearly what he needs in terms of the files that are required. So he knows what files are required. He's come forth and said, if the data that comes forth, when it comes forth, gives me more information and shows me that Kohberger was near the house. He wasn't out west at Hawaii Park, which has thin mobile phone coverage. That's where he thinks that Kohberger was. Nowhere near the house. Doesn't matter if he was stargazing or whatever he was doing, but nowhere near the house. Then he'll change his testimony. And by the way, he's doing this pro bono, guys. So no one at trial can go and ask him those questions about, oh, how much you getting paid, la, la, la. He's doing this pro bono. So this guy, he could be this guy's ticket out of this trial. It's very important. No, he wrote it. It's his software. It's his software. Now, you're right. Just because the phone wasn't there doesn't mean Kohberger wasn't, but it does really stuff with their timeline because 2 things, half Irish. Firstly, their whole timeline does revolve around him having his phone with him. Also, the other problem is they can't use any of the rest of their cell tower data or their footage of the car. So I'll show you this later on, but basically what we've got here is their map that they've made is based on not just cell tower pings, because the cell tower pings don't really prove very much, but the sightings of this white Elantra. And by the way, the white Elantra, they haven't got any pictures of the tag number at all. It's just a white Elantra. So they've got a white Elantra and they've got some cell tower pings, right? So they've got it driving around the house, apparently. Well, not around the house, but near the house, right? The only way they can get it near the house is with these videos of the car, a white car, right? So they can't use any of that if they've got him or the phone over 40 minutes west. They've got to throw all that stuff out, right? So that's a big problem for the state. All they've got left is this little bit of transferred DNA. That's a big problem for the state. Big problem. Okay. Yeah, and the timeline has no wiggle room. It's got, I think it's about 12, 13 minutes, something like that. Yeah, that's what I'm talking about, Jim Cox. So whilst it sounds like it's only about the phone, it's actually about the car as well. Okay. All right. And yeah, it's 6 motions to compel. And when we come to 6 motions to compel, there's another problem, right? So people keep saying that the reason why this trial is dragging on so long is because of Kohberger just loves being in jail. He doesn't want to go to the big boy prison. He doesn't want to be on death row. And so the defense is just dragging this out, and it's all Ann Taylor playing games. And there's still comments to this along this line. Whilst a lot of people's minds have been changed, and it's because she has been arguing for the hearings to be streamed still. The state really wanted to start having closed hearings about 2 months ago. They argued for the hearings to be closed about 2 months ago, right? But she argued for them to be open to the public. She said the public needs to know what's going on because Brian is innocent. Now, that was a big statement for her to make, especially as a public defender. But she came out and said, nope, the public needs to know what is happening here. And so we've been still allowed to see what's going on, and a lot of public opinion has changed since then, but not all. And just in this latest hearing, and it's only going to go for sort of 10, 12 minutes. I'm going to show it to you in a second. If you look through the comments, and we will have a bit of a look through the comments, because that trial date is in the middle of 2025, people are still saying she's playing games. It's all because of the state. Sorry, because of the defense. La, 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 la. 6 motions to compel, guys. And also, I've put a link at the top of chat, and that is to a recent pre-record that I did on this. And it shows you some responses to those 6 motions to compel, and it shows you in chronological order some of the exhibits or portions of Exhibit 1 that the state has started to hand over. And it starts with from motion to compel back in January 2023, guys, at a hearing in January 2023, all the way up till now. And there's a page and a half of it, blah, 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 blah. Right, so go and have a look at that. It's pinned to the top of the video there. It really is eye-opening. So that's really myth busting, that whole thing about who is holding up this trial. What's this? I have questions about the lead detective, Brett Payne. He had only been on the police force for 2 years, and it took him 4 hours to get to the crime scene. He had only been on the police force for 2 years, and it took him 4 hours to get to the crime scene. Not sure what you mean by that. 4 hours to get there, like physically get there. She wants it to stay public. Yeah, Ann Taylor, she is pushing hard for it to stay public because she needs people to see this trouble that she's having getting the information that she needs out of the state. In fact, I should play you that little piece of footage of her saying the public needs to start to question, is Brian innocent? And this is ridiculous that she has to actually tell people to consider whether he's innocent. He walks into that courtroom innocent. He walks in innocent. Everyone who's charged with anything walks in innocent. But she's faced with this impossible task, isn't she? Because that PCA, that probable cause affidavit, it was disseminated so far, the likes of Nancy Grace, the likes of Julie Grant, News Nation, so many of these really big organizations, they went out there and they took that PCA and they pushed it, didn't they? And it is just full of conjecture. And even the state now have gone and made a statement buried in one of their little documents saying, oh, the probable cause affidavit is irrelevant. Oh, it's irrelevant, is it? Well, so many things in it have now been debunked, like the whole thing about him stalking the victims. He never stalked the victims. He didn't even know them. He did not even know them. There's a lot of things in there that have been debunked now, right? But people still believe it. People still believe so many of the things that were in that probable cause affidavit because they were just put out there. And people wanted someone to be the killer. They wanted the killer to be found. Now, I am open to him still being the guy. Absolutely. But they haven't proven anything. The state have not proven anything. And we ain't even at trial. And the thing about it is that it's no one's fault except the state that they put all that stuff out there into the public. And now there's even a book. There's been a lot of stuff debunked. Yes. Why did it take the lead investigator so long to arrive to the quadruple homicide? Well, there were 2 roommates in there that didn't even call 911 until 8 or 9 hours later. There was that. There's a lot of questions about what happened that day. And let's just say that crime scene was locked down. I would love to know what went on in that crime scene, because to be honest with you, no one knows whether evidence was handled correctly, whether there was a correct chain of custody. This whole thing with the knife sheath, I am so suspicious of this thing with the knife sheath. I really am. And that's a rant for another day. I'm not sure. But let's just say that the state is asking us, Dali's here, I'm going to bring him in a sec. The state is asking us to believe a story, a narrative. And the story is that he went in there, stabby, and dramatically dropped the knife sheath. And, oh, by the way, on his way out, he saw, Dylan, and went, don't worry, I'm going to help you, and then walked out. And by the way, and he's also so clean and efficient that he never left any trace of himself whatsoever, except a tiny little bit of transfer DNA on the knife sheath, which he just happened to leave there. Right? Nothing of himself whatsoever. Nothing. Not a hair. No eyelash. No skin cells. Nothing. Nothing of himself. He didn't touch a wall. He didn't do anything. No fingerprints. It just doesn't make any sense to me at all. And then he walked out of that place with no blood of theirs. Nothing of theirs whatsoever. And then, even if he had walked out with something of theirs, no footprints on the ground, by the way. No footprints, nothing. He's Superman. He walked out, and his car and his house, nothing of them, nothing. And if you try and tell me that he managed to clean all that up without any signs left of them, and also no signs of cleaning, you've never watched a murder trial. Dali. Oops. You coming in?
Yeah, you have to change the little thingy.
Hello.
Hi.
Hello. So we know of one murder trial where there was a magician
Yes.
who managed to
Mark Jensen.
who managed to unalive somebody supposedly and leave no trace at all except for one little pinhead of DNA, apparently, that then just magically linked him to somebody who, well, in his case, we're talking about Zachariah Anderson now, in his case, there was not even a body to be found. It worries me with Kohberger that perhaps he may end up being the next Zach. And I don't know. I don't know Kohberger. I don't know his family like we know Zach's family. Ever since Zachariah Anderson, I have been so wary of these situations where we don't see the whole thing and then the state starts acting really, really shady. Like really shady. And for those of you who are watching now or what it might be watching later on replay and you're not aware of the Zachariah Anderson case, please have a look at it. Wisconsin versus Zachariah Anderson. You can go to zachariahanderson.org. Have a look at it. This guy, he was convicted, guilty verdict, and his case, there was no body. There was nobody to be found. And it was intentional homicide, first-degree intentional homicide, and hiding a corpse that didn't exist, right? And again, just one little bit of transfer DNA and a bunch of concocted evidence. So it worries me that if this thing gets to trial, it won't matter, right? It will not matter whether or not none of the evidence really adds up. All the jury will see is that tiny little bit of DNA. That's it. All right. Hello, MLS God of Law. Now, I've been talking a lot. They used the knife sheet class trace DNA left at the scene and trash DNA from PA to connect him. Exactly. That's what's happened here. And so, yeah, I do worry a lot about that DNA because I feel like that's all the jury will see. That's all the jury will see. That's all they saw in the Zach case. I believe that's all that gave them the guilty verdict. And I think that's all they're going to see. Unless Syray can definitively show that he was 40 minutes to the west. He was 40 minutes to the west. So if that happens, I think we could be looking at a motion to dismiss. We could be looking at a motion to dismiss. If this doesn't go to trial, that's it. I think that's his only option. It's just not getting to trial. Yeah. Okay. So let's have a bit of a look at the hearing from the other day because it's quite short and we're going to hear what went on with the scheduling. Everyone was extremely just on the edge of their seat trying to get to a date for the trial. But those of us who watch trials, though, like 3 years for a murder, especially like a quadruple murder with a death penalty, 3 years doesn't really seem that out of the ordinary, I don't think. No, but it seems like everybody else, like anyone watching it from, especially like those thinking of the victims, I suppose, are like, why is this taking so long? It should be, hurry up, get him in front of the firing squad. It's like, it's kind of important we get this right, guys. All right, let's go. Okay. You like my little Brian down the bottom there? Yeah.
Very seductive.
Oh, he's seductive, is he? Okay.
CR 2922-2805. Present in the courtroom is Mr. Kohberger, represented by Ms. Taylor, and Ms. Massett and Mr. Logston are participating over Zoom remotely. The state is represented by Mr. Thompson and Ms. Jennings, Latah County Prosecutor's Office, and Mr. Nye and Ms. Beatty are participating over Zoom remotely. So we're here for a scheduling order, and I think we're
It's
about
great success.
13
We'll put a link
months
up.
from the arraignment. And I think at this point, this is my opinion, that we're getting to a point of diminishing returns. And I sent to council last Friday on a proposed scheduling order for a lot of things, deadlines, including setting the trial. And so I also have set this hearing so that we can discuss this and see kind of where everybody is. So let me start with the state. Thanks.
Thank you, Your Honor. We've reviewed the court's proposed scheduling order with the attorney team, and we are agreeable to it. It makes sense that we do the trial in the summertime when high school is out across the street and when the university is out and the conflicting activities. And the schedule that Your Honor proposes is acceptable to the state. I would note just a minor detail that June 19th is also a legal holiday. The court specified July 4th as a legal holiday. We wouldn't be able to hold trial, but
Sure.
19th as well. Other than that, we have no objection to the court's proposal.
It's Santa
All right.
Claus.
Thank you.
What?
As I went through all of this,
People
there's
say that
gonna be a lot of
Bill Cosby looks like
motions,
Santa
a lot of
Claus.
hearings, a lot of work. There already has been a significant amount of work, as we all know. And when I tried to balance this out, I do think it was it's pretty fair, balanced, and I hope realistic. So, Ms. Taylor.
Thank you, Judge. Your Honor, first, I know the court has listed this as taking place in Latah County. We haven't been heard on our change of venue yet. That's to come
Totally
in
understand
August.
that.
So I don't want anybody thinking I'm agreeing to Latah County is all. The June of 2025, that's the time frame that we have been working towards. I am hopeful that we can come in there. We're working towards that date. I think it's reasonable to set that date. As the court's aware, mitigation is something that takes a significant amount of time. We've had that underway since the day we took this case. We continue to work that very hard. I spoke with our mitigation expert last night about this date. And there's a lot of work yet to be done, but we're still working towards that. So I think it's reasonable to set that. I just want the court to know that that's not finished at this point. That's very much ongoing, and new things are coming out that we need to follow up. But with that said, I think it's reasonable to go ahead and pick the June of 2025 as a trial date at this time.
And by the way, I think you understand that.
That's important. So she really wants a change of venue. And fair enough too. If you haven't been following what was going on about sort of 2 months ago, she actually, defense, put out a survey to the local area, and the survey asked questions of, I think it was about 200 people, maybe a bit more, asking whether people were or had an opinion on certain aspects of the case, such as one of the questions was, do you believe that Kohberger stalked the victims? And that was directly from the PCA. In fact, all of the questions were about items that were directly from the probable cause affidavit, and the results weren't good. The results were that the population of Idaho County was tainted, very tainted. They were very much of the belief that Brian Kohberger did do all those things and was very much likely to be the murderer. So, that being the case, based on those survey results, and the judge, by the way, said, you know what, it's fair, and looked into case law, looked into the statutes, and said, there's no reason why you can't do this survey. Lots of people were very much against the survey, but it was fine to do the survey.
Yeah.
The area where the case was to be tried, like the local area, good luck getting a jury that's going to be impartial. But that said, other areas in the vicinity, are they going to be any better? That's the other question. So she needs a change of venue. I just don't see how Brian Kohberger is going to get a impartial jury there, but where they're going to go, not sure. Probably somewhere more populated. So Idaho County is very sparsely populated. It's a small town.
Sure.
And you need to get somewhere with a larger population, therefore more people to choose from. This is such a huge case. It's just touched so many areas, and you need somewhere where there's more people who are more distracted from the media and more likely to just be going about their everyday lives and not have heard so much detail about it. It's too much to ask that people just haven't heard of it at all, but to ask that they haven't heard all of these details when they have been living in that close area is just too much, I think. Anyway, so she had to put that on the record, that she's not forgetting this change of venue thing. She's fine to start talking trial dates, but by the way, I still want to change of venue, guys.
Council understand that, but this is a 3-month trial. So
3-month
I
trial.
was calculating 2 weeks to set the jury, then 8 weeks of trial, and then 2 weeks for mitigation and sentencing. And I mean, that's a guess, but I think it's enough time for all of those things to take care of. And obviously, the last 2 weeks would only be if Mr. Kohberger was convicted. Okay, go ahead.
Thank you, Your Honor. I do want to bring up a couple of issues I have with some of the deadlines. I looked this over. Our team has talked about it. I've gone over this with Mr. Kohberger. I do have a couple of concerns about the deadlines, and I'll just bring those up to the court for the court's consideration. As far as motions challenging the death penalty, and that's in right under motion practice letter A that the court has on its draft, we can have a lot of those filed by September 5th. I would note for the court that that's ahead of the state's final discovery date, and that's ahead of the state's deadline to produce its aggravation case that it will use. We can meet this September 5th deadline, but we're going to ask the court to give us a little leeway when there's something new that comes our way. If there's an amendment to a motion or a new motion that becomes relevant based on something new, we'd like a 2-week window after receiving something new to file that. But the bulk of it we can get in by the deadline that the court has asked here, and that's just not a problem.
Sure, I understand that. I mean, I looked at that. I wanted to have that early because, you know, it's a bigger question.
Yeah.
And I was aware of the Ross case. I think you had 16 motions in that case. So I wanted to sort of address those issues early.
Your Honor, we can definitely do that. We can address a lot of things early. We just don't want to be precluded from bringing an amended motion or a new motion if something new is filed that would have been relevant to something we've already filed.
I'm not going to prevent you from doing that.
Perfect. Thank you.
And by the way, a lot of these deadlines, I mean, you can certainly do them earlier if you'd like to. I would encourage everybody to do that. Thank you.
Your Honor, then moving on, the motions in limine under letter C, the court has suggested February 13th as the date for that. I think in large part, we can do some by then, but the exhibits that we'll exchange and witness lists that we'll exchange aren't due until after that. And again, I think there might be additional motions that would be relevant after those things have been exchanged. So if the court wanted to move the whole deadline so we had all of those motions in limine at once, I think that would be reasonable. But if the court wants to keep this deadline, as long as we have the ability to bring more motions in limine based on new filings, we'll be okay with that as well.
Sure. And I was also thinking about, I guess experts, for example, I mean, they may have longer hearings that, we're going to have to work through all of these things. I mean, this is just a structure.
Thank you. The court had listed March 14th as a trial brief date, and that is ahead of some of the other deadlines, recognizing that the trial is the innocence phase and the sentencing phase, if it happens, is the mitigation and aggravation. I would just say this is a fine deadline, but we won't be touching anything to do with our mitigation by then, if that's what the court anticipates.
That's interesting. Okay, so mitigation, that's if he's convicted. So they're talking about 2 weeks for that. So let's just break this down. They're talking about a 3-month trial, right? So 12 weeks, 2 weeks for jury selection and mitigation. That means the sentencing phase, right? So 2 weeks for that. So in reality, we're talking actually 2 months, so 8 weeks. So if you take away the 2 weeks for jury selection, and let's be hopeful here and say that there is no death penalty or there is no sentencing, and go, okay, well, if there is no sentencing, then there's no 2 week, God, imagine that, 2 weeks of argument about whether or not he should lose his life. Sorry, I'm really against the death penalty, so that's horrible, the 2 weeks of that. Then we're looking at 8 weeks of trial. So basically what we just went through with Karen Reed, 8 weeks. Marathon still, but it's less.
Anticipated?
Yes.
Okay, perfect.
I think we had March 3rd for mitigation. I figured by then you would pretty much have that in hand.
We hope to. That brings me to the last point I wanted to talk about. The court has proposed setting a mutual exchange of aggravation and mitigation materials, and I'd ask the court to reconsider that. We will aim for our March 3rd deadline. That's our plan right now. If something changes that, then we'll come back and let the court know and talk to counsel. But would ask that the state's aggravation package be provided to us earlier than the same day as our mitigation. Should we get to that point, the state has the burden of establishing the statutory aggravators. There are some things I think I might be able to guess about how the state's going to try to present information. but I don't think I should have to guess. I think I should have that information well ahead of providing the mitigation that will be presented in response to any aggravating information that's presented by the state. So I'd ask the court to set the date for the state to produce its information much earlier than ours. The state filed its notice a year ago yesterday, and I have a lot of questions about what the state would intend to use to try to establish many of the statutory aggravators they've listed. I know I've heard the court talk about super due process in a capital case, and I think it's appropriate for us to be on notice and be provided discovery, to be provided a full range of what the state intends to use to establish those if we ever get to that point. And I think we need those ahead of our deadline for mitigation. So I'd ask the court to move that deadline up quite a bit earlier. And that's it.
Thank you very much. Mr. Thompson, do you have any issues about having the aggravation in advance for a period of time?
No, sir. As long as we will have the option, the ability to supplement that once we see whatever the defense plans to offer in the way of mitigation.
Well, I'm appreciating that, with these deadlines, that we're going to have supplement all the way along. I just don't want to be scrambling around a month before the trial. We're all going to be very, very busy. And the more we can resolve certain motions, supplements, whatever we need to do, I'm trying to do this sooner than later.
Yes, sir. And that's our preference as well.
And Ms. Taylor as well.
Yes, Your Honor.
But just to make sure, though, you have to do your job, and the state has to do its job, and I have to do my job. But I think this is a great step, okay, to set these deadlines and hearings so that we can move through this. It's going to take a while, but anything else we need to address today, Mr. Thompson?
I don't believe so. Thank you.
Ms. Taylor?
No, Your Honor. Thank you.
Okay, well, it's very short, and I'm grateful that everybody is working together. Thank you. Okay. Take care, everybody. We are adjourned.
So did I miss it? Did they actually announce the trial date at the hearing? Because I've got a document that states the trial date.
Yeah, I think it's June or July of next year.
It's July.
July.
Yeah. Am I missing it, or did they actually state it?
I think they did in the beginning or near the beginning.
I can bring the document up in a moment. Yeah, it's
We said it's what, a 3-month trial?
June 25. There we go. Yeah, June 25.
You said it was a 3-month trial?
It's 3 months, but it's 2 weeks of jury selection. And so that would be the beginning of jury selection, June 25. And so therefore, June 25. Hang on.
Okay, but if that's when jury selection begins,
Mm-hmm.
school's going to be back in session well before it ends.
Yeah, too bad. But you know what? There's no way Ann Taylor is going to be cool with it being in Layton County. Yeah. There is just no way. There is just no way. She will be not standing for that, and she just put that on the record. It's just not going to be possible to get an unbiased jury there. So hang on just one moment, guys. I have the document. Mr. BK Bushy Eyebrows. here we go. Scheduling order. Okay. So it says that 8:30 a.m. June 2nd. What?
Oh, that's probably for jury selection then.
Yeah, okay. Jury trial
makes
shall
sense.
commence. Yep. Okay.
That's
So
right
jury
after school
trial.
is out.
Okay. So, yep, rightio. So jury trial shall commence 8:30 a.m. June 2, 2025, courtroom 3 of Leda County Courthouse, and will run until August 29, 2025. So when does school start?
Usually, it depends on every state, but usually August sometime, maybe
August.
early September, but that's rare.
Yeah. See, I have no idea because I'm an Australian, and around here we have like 2
Well,
weeks off in the middle of the year because it's winter.
School usually gets out end of May.
Yeah. Okay. A final pretrial conference will be held April 3, 2025. Yeah, okay. Motions to suppress evidence and any other motions shall be filed no later than November 14th, 2024. Motions in limine shall be filed by February 13th, 2025. Discovery completion. Now, this is the big one. The state's discovery deadline is September 6, 2024. That's not long away.
Good.
That's really, really soon. And that means that all of this stuff that has been included in the motions to compel, and there's been 6 motions to compel, that's all going to be supplied to Ann Taylor's team by the state by then. And also the stuff that they've asked for from the feds as well. And that means the state has to get it from the feds. And that's tricky because the feds have gone and said, the FBI here, they've gone and said, oh, TUI rule. They've gone and used this TUI rule thing, which supposedly is for like top secret government stuff, like national security kind of information.
Terrorism things.
Yeah, that kind of stuff. It's not supposed to be for murder cases where it could include like some exculpatory evidence for somebody who may be innocent of a crime. Just working with local authorities in order to help solve a case. That's not, as far as I understand, that's not what the TUI rule is for. Might be wrong, but what my research shows, that's not what it's supposed to be for. But you can't question them because they're the FBI and they won't say anything, right? Hey, Kat, how's it going?
Hey.
Ooh, I've missed everything. That's okay. Let's go back. Yeah, so I just don't understand how this is fair. A lot of things aren't fair, but I don't get how this is fair. That the FBI, who were very happy to be involved in this, and I'll show you this. They were very happy to be involved in this document, and this 166-page document, which is the PCA, right? The probable cause affidavit from all the way back in 2022. So this is, 2022. This is the thing that got Kohberger arrested, right? And it is full of conjecture. And I wanted to show you this part here, especially. So this is the part about the cell phone. This part here. So we go and have a look at, and I don't know how to get hold of a version of it that shows you better examples of their map that they made, because all I've ever seen is these horrible photocopies. Statement of Dustin Blaker. The below information is provided by Sergeant Dustin Blaker, a duly appointed and qualified and acting peace officer within the County of Bleda, employed by Moscow Police Department in the official capacity and position of sergeant, and I've been trained and qualified peace officer. What's a peace officer?
Police officer.
No, peace.
Yeah, it's the same thing. It's just another name for it, depending where they are in the country. Like troopers in Massachusetts.
Really? I've
Yeah,
never heard that in my life.
They're peace officers, like to control the peace.
Okay. I see. Okay. I just thought it was a typo. I'm being assisted by other officers of Moscow Police Department, members of Idaho State Police, and agents of the FBI. So on November 13, 2022, at approximately 4 p.m., Moscow Police Department, Brett Payne, he testified at the hearing at the end of May this year, remember? And I responded to 122 King Road. Yeah, that's right. 4 p.m. Ronnie, was it Ronnie? Yes, that you said that he was like 5 hours late or something. 1122 King Road, Moscow. Hereafter, King Road residents to assist with scene security and processing of a crime scene associated with 4 homicides. Upon our arrival, the Idaho State Police forensic team was on scene and was preparing to begin processing the scene. MPD Officer OFC Smith, one of the initial responding officers to the incident, advised he would walk me through the scene. OFC Smith and I entered the King Road residence through the bottom floor door on the north side of the building. OFC Smith and I then walked upstairs to the second floor. OFC Smith directed me down the hallway to the west bedroom of the second floor, which I later learned through Xana's driver's license and other personal belongings found in the room was Xana Knodal's, hereafter Knodal room. Just before this room, there was a bathroom door on the south wall of the hallway. As I approached the room, I could see a body, later identified as Knodal's, laying on the floor. Knodal was deceased with wounds which appear to have been caused by an edged weapon. Also in the room was a male, later identified as Ethan Chapin. Autopsy report provided by Spokane County Medical Examiner Venus Singh, dated December 15, 2022. Sharp force injuries. Okay, so this goes on. What I wanted to get to was this stuff down here about the phone. Oh, and the security camera. So at approximately 4:17 a.m., a security camera located at 1122. It should say 11. Oh no, it's across the road. 1112 King Road, a residence immediately to the northwest of 1122 King Road. Yes, picked up distorted audio of what sounded like voices or a whimper, followed by a loud thud. A dog can also be heard barking numerous times, starting at 4:17 a.m. Okay, so the security camera is less than 50 feet from the west wall of Knodal's bedroom. Okay, so all of this stuff is starting the digital forensic evidence. Now, here we have then starting to mention the vehicle. And they are talking about the vehicle as we go on, as if they've identified it as Kohberger's. Now, never have they actually identified it as Kohberger's. They never got a tag number, right? They've only ever found, loosely identified it as a white Elantra. Yet, they've managed to make these maps, overlaying it with cell tower data based on this white Elantra, right? Based on the footage of a white Elantra going past the house. So a review of footage from multiple videos obtained from the King Road neighborhood showed multiple sightings of suspect vehicle 1 starting at 3:29 a.m. and ending at 4:20 a.m. These sightings show suspect vehicle 1 makes an initial 3 passes by the 1122 King Road residence and then leave via Willetta Drive. Based off my experience, and this is where we get to the sort of, this is just me talking now, and it's the guy in the PCA. It's not fact, it's opinion. Based off my experience as a patrol officer, this is a residential neighborhood with a very limited number of vehicles that travel in that area during the early morning hours. Upon review of the video, there are only a few cars that enter and exit this area during this time frame. Suspect vehicle 1 can be seen entering the area a fourth time at approximately 4:04 a.m. It could be seen driving eastbound on King Road, stopping and turning around in front of 500 Queen Road 52, and then driving back westbound on King Road. When suspect vehicle 1 is in the front of King Road residence, it appears to unsuccessfully attempt to park or turn around in the road. The vehicle then continued to intersect to the intersection of Queen Road. Okay, so there's all of this talk. And then if we go down, some sort of garbage map. White Elantra. Going.
I don't see color.
And then we have phone, right? So we go down to here. Now, phone stops reporting to the network, which is consistent with either the phone being in an area without cellular coverage, the connection to the network is disabled, such as putting the phone in airplane mode, or that the phone is turned off. The 8458 phone, that's been identified as Kohberger's phone, does not report to the network again till approximately 4:48 a.m., at which time it utilized cellular resources that provide coverage to ID State Highway 95 near Blaine. Between 4:50 a.m. and 5:26 a.m., the phone utilizes cellular resources that are consistent with 8458 phone traveling south at ID State 95 to Genesee. Okay, so to wrap this all up, they make this map, which you can't really see, but I have for you something better. Okay, so now I'm just gonna make this a little bit easier to see. Take away my little bye, Brian. Okay, so someone went and put a little highlight on the thing from the PCA. So if I go and there we go. So this is from the PCA. So the possible route as shown in the PCA, and this is after the time of the crime as they think it happened in the PCA. No one actually knows when it happened, guys, right? So let's just remember that. No one actually really knows. But this is the possible route of the cellular device location. So on the morning of November 13, 2022, Kohberger's phone stopped reporting to the network at 2:47 a.m. while it was in central Pullman and started reporting again at 4:48 a.m. just south of Moscow near Blaine, right? And then they made this thing. Now I'm going to show you, someone else has gone and made a better version of it because you can't see it in the PCA. Okay, so someone on Reddit made it a bit clearer, right? So they went and popped it into Google Maps. And it's important to note the most geographically accurate of the check marks are video sightings, but they're just of a white Elantra. That's it, right? They're not of definitely his car. They're just video surveillance of something that looks like a white Elantra that's kind of like his, but they didn't get a tag number, right? So the white Elantra was never identified by tag number. The cell pings are only in the general vicinity, right? They're not at the location. So you guys have been watching the trials for a while, and you've seen cell tower experts do their thing, and they show kind of like, see the graphic there,
Mm-hmm.
right? Yep. They show that it's a circle, right? An azimuth, I think it's called, right? And there's like a pie chart, and it shows you like where the space is that your phone could have been, right? When it was pinged, it just means that your phone was in like that space. It doesn't mean your phone was there or there or there. It means it was in that space, right? So they're trying to, when they put these little dots down, they're just saying that the phone was in this kind of space, right? Now, the way that this has all been worked out based on the PCA is, see how this person's done this quite well. See how they've got little cameras icons there?
Mm-hmm.
So the camera icons, they are video sightings. So we're not sure about that, but there was video of a white Elantra at 1112 King Road. Then at 4:21 a.m., there was video of a white Elantra at 1330 Lindell Lane at 4:21. There was video of a white Elantra then, and then there was a cell tower ping, and I would expect that's actually the tower there, rather than it being like a spot of land where the phone was. I would expect that's actually the tower, that spot there. Cellular pings Genesee, because it's not like a what do you call it? Like, it's not an address or anything like that. It's just a spot. So that's there. That's there. And then it keeps going, right? So, and then there's some more. See how there's some more cameras up here, right? So they've gone and plotted all this. But what I've gone and said here is that the most geographically accurate of the check marks are actually the most inaccurate of the sightings, because they're just a white car. We don't even know if they're the same white car. They're a white Elantra. So what do we need to do to hone down on where he actually was? We need better technology. And in order to do that, hang on just a moment. In order to do that, well, what do we need? We need some software that pinpoints people down a little bit further. And who's made that?
Siren.
Tell you this dude, right? So this dude here, hang on, why can't I make that full screen?
That phone connects to the network for certain reasons. I can see those connections. It's not a wiretap. I can't hear anything. I can't see content.
This
But
guy
I can
here,
tell the phone is connected to a particular
let's
cell.
pause.
A couple of different.
Okay, so this guy here, Tyree, defense witness for the very first time, usually, exclusively, always a witness for the state. Ann Taylor manages to get him as a witness for the defense. And as I said earlier in the stream, actually at the beginning of the stream, he wrote the software. Now, if you were watching the states or the Commonwealth's testimony, and I'm not going to say it was great testimony at all, but if you were watching the state's testimony in the Karen Reid case or the Chad Daybell case, which is important because that's Idaho, all right, you would have seen cell tower or cell data maps with a giant Trax logo all over it, TRAX. That's because this software is used by local, state, and federal agencies all over the US, because it is, and I'll show you what Police Magazine, Police Law Enforcement Solutions Magazine calls it, Trax CDR mapping. Trax is the most accurate CDR mapping tool available, converting historical phone records into dynamic visual maps in minutes. Trax uses realistic RF footprints for 6 million sectors across the United States. ZX, which is his company, brings you the most comprehensive CDR investigation possible. police magazine. Right. So that's a bit of a big deal.
Yeah.
Ghost, that is the only time it was ever not accepted. And you know the reason why it was not accepted in the Colorado court? It was because he only had an associate degree. They didn't like his qualifications. So he actually spoke on that on his own channel. They didn't like his qualifications. So, but that was the only time he's not been accepted in Colorado. Yeah, it's unfortunate. But yeah, people keep bringing that up and he laughs about it. But yeah. So anyway, this dude, I wanted to just show you a little bit of his testimony from the last hearing, like the hearing before, and just give you a little insight into how dangerous he is to the state. Let's go. Oops, hang on, but before that. Oh yeah, sorry. I'll just finish what I was showing. Okay, so we looked at that. Oh yeah, okay. No. I just want to finish this. Okay, so what Cy Ray will testify to, if, assuming that the state comes forth with the data that he needs, and this is what I'm about to show you in the testimony, if the state comes forth with the information that he needs, he will show that at that time when the phone was apparently switched off or not responding to the network, the reason it was not responding to the network is because his phone during the time prior to that little map that they made, right, when they said that it went off nowhere, but they think that he was in the house stabbying. In fact, it was going this way, right? So according to Brian's alibi, around 2 a.m., he was actually traveling west-southwest that way, down here to Hawaii Park. And you can see the terrain down there. It's mountainous, right? Now, Andrea Burkett actually went to one of the hearings back in April, I think it was, the very first time that the alibi was put forth. This alibi was put forth. And she went back via Hawaii Park, and someone asked her, hey, how was the phone reception there? And she said there was zero phone reception there. None. Nada. No phone reception there. So this whole thing about the stargazing, etc., I know it sounds funny, but it doesn't really matter what he was doing there. If he was just sleeping or if he was just hanging about reading or whatever, it doesn't matter. If he was there with his phone and his car, that matters. Now, here's the other thing, right, guys? He has the other thing is his degree is in cloud-based forensics. So he was studying criminology, but his major was actually in this. So what Cy Ray teaches, what Cy Ray's specialty is actually in this, right? So it's super important. If he knew that the phone would somehow give some data off, even without any connection to the network, there was going to be something, right? So if he knew that GPS signals would pick up some sort of data out there in the middle of nowhere, right? Like some sort of Spotify connection or some sort of Bluetooth connection or some sort of Find My iPhone, or there is apps on your computer, on your phone, that are apps that are constantly trying to connect to the network somehow. Like they're always searching for some way to just find a signal, right? They're constantly doing it. And if they can't get the information that they want, they're at least trying to create just a geolocation. There's got to be something on there.
Yeah.
Right. And he knows that. Kohberger knows that. He studied it and he knows it's all up there on the cloud. Right. And I can just imagine this guy, if he didn't know where he was that night, and it was, remember, he was arrested, I think 7 or 8 weeks later after the event. Remember, if he was just arrested and then just took his phone and he went, okay, look, I don't know where I was. I didn't do this thing, but here's my phone. Here's my phone. So if he was just arrested and he said that, gave him the phone and thought, look, there'll be something on there. I know there'll be something on there. There can't not be something on there. Just go through it. You'll find something. And then he said that to his defense attorney. He thought, look, there's got to be something on there. Just tell them to go look through it. There'll be something there to show where I was. I go out driving at night. There'll be something there. And now, 18 months later, this is the problem that we have. What he didn't bank on was that they wouldn't be able to get the information from the feds. Imagine that. And look at this. Additional information as to Mr. Kohberger's whereabouts as the early morning hours progress, including additional analysis by Mr. Ray, will be provided once the state provides discovery requested and now subject to upcoming motion to compel. If not disclosed, Mr. Ray's testimony will also reveal that critical exculpatory evidence further corroborating Mr. Kohberger's alibi was either not preserved or has been withheld. It's a big deal.
Yeah.
If they don't got it, they can't use it for their own case. So if they don't go forth with this stuff, they just can't use it for their own case. Simple as you can't have your cake and eat it too, state. So come forth with it. Come forth with it. All right. So I just wanted to play a little bit of Mr. Ray's testimony from the last one.
Have you shared it? Should I play some music? You okay? Hello? You okay?
Oh, sorry.
Otherwise, you're driving in circles where the phone may not be. So it gives law enforcement the ability to have a general understanding of where a phone is operating or functioning. And then I can use the cell site simulator to do it. There's a number of reasons an agency might do this. This search warrant actually says they were requesting these because they were trying to locate where Mr. Kohberger was.
Going to the understanding what's happening right now, is that?
No, that's I never said they were complaining about not having the Celebrite download. Yeah, they're asking for the JSON files. He's going to mention it all in a second, right? So there's a bunch of data that they need to actually create the map, right? So it's a map. It's not Celebrite data at all. I never said Celebrite download. So that are you referring to my reference to the Karen Reid case? Because that wasn't what I was talking about. There was a map that said tracks on it. So it's not about text messages or anything like that. It's about location, geolocation.
Used so that you don't just know where the phone was 5 minutes ago, but you know where it is right now.
Within a time period, it's not a perfect system. There is a little bit of a delay and the information comes in intermittently. So it's not a real-time feed of giving constant evaluation of where that phone is. But if you know what you're looking at and you've done it long enough, you can get a pretty good idea.
I heard you say that this is to try to find out where Mr. Kohberger is. In the information that supported this warrant, didn't they already know where Mr. Kohberger was?
I reviewed a lot of documents that clearly state not only did they know where he was, they had a surveillance team with eyes on. So yes, it would be unusual for an agency to request this type of equipment. And I need to qualify that. This truck driving around is about $1 million. It's not something you just park in the garage at night. It's a very expensive resource. It's a very technical resource that requires a lot of training and skill to use properly. So typically when it's used, it is used for, hey, we don't know where this person is at and we need to find them. And to be very honest, I don't have an issue with that part. I've used it 1,000 times. It's a good tool. It's a great tool. However, if I know where a subject is and I'm physically watching him, it's probably disingenuous for me to get a search warrant justifying it that I need to find him.
Makes sense. Thank you. I want to switch gears and talk about the CAST-BIZ program.
Okay.
Are you familiar with the CAST-BIZ program?
I am.
Why?
I've worked with a lot of agencies that have used it and accessed it. So I've worked on cases where we've used different mapping platforms to do kind of a compare and contrast as a peer review. So they would create a work product, we would create a work product, and then we would check each other's work. Because at the end of the day, we're just looking for the accuracy. We want to see if there's any errors in that. I would say I probably have worked with the CAST-BIZ reports several dozen times, maybe 50. I'm aware of some of the updates they've made. Like I mentioned earlier, I'm aware that they have added a feature that you can now input tower density, so you can create these estimated ranges, if you will. And I'm very familiar with the basic settings that you have certain controls you can do, like time zone. What time zone am I going to have? Am I going to use the coverage density? Am I going to save my work? Am I going to just exit the program? I physically have seen those features a number of times.
As it relates to this particular case, have you had a chance to look at any exhibits prepared by Detective Mallory using the CAST-BIZ program?
This is the other thing.
Yes, but I should clarify. One of them I'm pretty familiar with. I believe it's State Exhibit 48 that was used for the grand jury.
Okay, so he also trains police officers, detectives, and FBI agents in the use of the CAST-BIZ software. Now, we looked at the CAST-BIZ software, what CAST-BIZ software is, in a previous stream. And if you recall, the state is requesting the CAST report. So there's CAST-BIZ software and there's CAST report. There's also such a thing as a CAST team, separate, all separate things, but they're all to do with the cell tower data evidence, right? So CAST-BIZ is supposedly a free software, but it's only available to law enforcement. But this guy here, he's a trainer, and he actually is testifying as to whether people in law enforcement are competent in the use of the software. And it's going to get a little bit embarrassing in a minute because he's about to actually comment on whether or not Detective Payne and Mallory are competent in their testimony, which was given prior. So let's look at that.
The others I had never seen until I believe it was last week. So I'm probably gonna have to look at those if you're gonna ask me questions on those, but states 48 are not pretty.
I want to ask you a question about that. I'll ask you some other questions about the records we received last week. I'm going to have you handed what was admitted last week as states are, just my copy of it so that you know what we're talking about here.
Okay.
I'm curious about what was needed to go into CASVIZ to create that.
So when I open the CASVIZ program, I have to input what I'm going to refer to as source data. So let me define source data is any data that is an electronic format, typically a text file, that the CASVIZ program is going to link to this mapping session and use that source data to create the images for scene. I can tell you right off the bat, without a doubt, this one is linked to two different source data. One is going to be a set of CDR records, so the regular AT&T CDRs. And then this particular exhibit would require the regional AT&T tower list, which is a text file that contains all of the cell site locations, most likely be Western Washington, Idaho, and Eastern Washington, Idaho, and Western Montana is typically that region. But there's no way this map was created without the AT&T tower list. It's physically impossible.
Is the AT&T tower list, was that contained in the call detail records that were obtained by search warrant relating to Mr. Kohberger?
It was not.
All right. And in the CASVIZ program, when you input the CDR call detail records and you input the tower list, does that program create any type of log?
It does, and I want to make the record really clear on what I'm testifying to, because it can get kind of confusing when we start talking about different versions. The CASVIZ program offers two styles of mapping. I can just default to a normal size, what they're going to refer to as a wedge shape, which is representing the sector the device connected to. If I was doing that, all I need is the AT&T records, because the AT&T CDRs actually have the tower information that's required for that mapping. As soon as I change that feature, though, to add coverage areas, the estimated coverage areas, and now these little wedge shapes or these sectors are all different sizes, the CAS program has to be linked to a tower list that has location of all of those towers. That's the only way the program knows how to size the cell sites. So I just want to clarify, if I'm mapping the CDRs without coverage areas, all I need is the CDRs. If I'm mapping the coverage areas in the CASVIZ program, I have to have a tower list. This one, I can see 3 different sectors. 2 of them, if anybody sees this exhibit, just to make the record really clear, they're really hard to see. One of them is just under the N as in Nora, under the word Pullman. The other one is right by the L in Pullman. But they're different sizes. And that tells me right off the bat that the AT&T tower list is used.
And why are they different sizes? Mind me again, please.
Cell tower density. We see a great big sector right in the middle of this map, and I'm not familiar with the area here. It's basically south of Pullman and south of Moscow, kind of out in the middle of nowhere. Not a lot of cell towers out there, so one tower covers a very large area. Then the other 2 are going to be in Pullman. It's kind of hard to see on this map, but I believe they are going to be ones that are on Washington State University campus. A lot more cell towers, the coverage is much smaller. So it's just a way to look at tower density to kind of estimate how far certain towers may connect to a phone where others may have a very short range.
And is it based on that difference in towers that causes you to know that a certain type of tower report was used?
Yeah, it is a basic algorithm that uses tower density, and the only way to determine tower density is to have a list that has all of the towers, not just the ones that were used by the cell phone.
Okay. Do we have the list of the tower list that was used by Detective Mallory in developing that exhibit?
Detective Mallory stated he did not use a tower list to create this exhibit, so know, but I'm not sure how to answer that other than I haven't seen one.
Should it be there?
It is physically impossible to create this map without it.
If you had the logs from the CastViz program, would that give you more information about what was used?
It would. We would need the
Be
CastViz
good.
program as well. The logs are saving certain settings, and it's a JSON format, which is just a software language. We could load that JSON file into the CastViz program, and for the most part, we could replicate exactly what was done.
But
If I understand that, to turn it around in order to.
if you recall, Mary just took screenshots.
Mm.
He didn't save his working files. Remember? He used Windows snipping tool.
Yeah.
replicate that and see what was done, you would need a CastViz program. Is that right?
Correct, and preferably the same version that was used.
And you need a JSON file that was made by Detective Mouth. Is that right?
Correct, and depending on where the software program is, we would probably need the source data again because it may not be automatically linked. Anybody who did PowerPoint 10 years ago, you make a PowerPoint on one computer, you save it on a thumb drive, you go to a different computer, all the links are broken. It could create a situation like that. So you would probably need the original source data as well, just to be sure.
What's the original source data?
In this case, it would be the AT&T CDRs and the cell tower, the regional cell tower list.
From that time?
Correct.
Okay.
Well, no, if we're trying to recreate this work, this is where it gets a little bit complex. We would need the exact AT&T tower list that Maori used but didn't use, which makes it really difficult because AT&T updates these on a fairly regular basis. If he used a November list and I use an April list, the results could be different.
Okay. Why would the results be different and given the month of the video?
AT&T could have added or subtracted cell sites in the area, which would change the tower density. They could also reconfigure those cell sites, so maybe they point different directions. Given the rural area, 2 or 3 months, I don't think you're going to see much of a change, but it's always possible. So if we're talking about recreating this exhibit exactly the way it was, we would need not just the regional tower list, we would need to know which version of the regional tower list to use.
Is that generally why people in your field save their work?
We're talking best practices 101. We're creating a work product
that
that
why
is going to be
people
used
save
in
their
forensic nature, not showing
They're not
how an
dummies.
extraction is done, not showing the source data that I use to create an exhibit. It happens,
See you, Bob. Thanks for
but
being here.
for the most part, it's unheard of, especially somebody who is a subject matter expert in digital forensics. I won't say I haven't seen it, but it is rare.
Thank you. Let's move on and talk about the CAST draft. Let's have you.
I'm sorry, Ms. Taylor, the past report.
Draft. Have you?
Can I ask how much longer on this? Because we're 90 minutes. I need to give the quarter break.
How much longer? Because
But if
I've
you're
got
going
no
to
idea what
finish,
the hell you're
in
talking
5 or
about.
10 minutes, that's probably sufficient.
Your Honor, I would say we probably have 15 or 20 minutes or so if the court wants.
Okay, so here's the thing, right? This guy knows what he's talking about. It's so clear. He's just completely called out Detective Mary. And did he get to calling out Detective Payne as well, or did we not see that in that one?
I don't think so yet.
Yeah. In fact, yeah, he's also gone and hang on, is this the most important part of the stream? Yeah, he also said that Detective Payne was mistaken in his interpretation of the CastViz report. It's very embarrassing for the state. It really is, because this guy, he runs rings around the the detectives, obviously, they only have a rudimentary knowledge of the software and the information that they're presenting. I'm sure that the state will bring forth some form of cell tower expert, but they're going to have a hard time bringing someone of this level because,
Yeah.
like I said, this guy wrote the software and he is the trainer. It doesn't really matter, though, because when it comes down to it, this discovery needs to be handed over. And Cy said in this hearing right here, he'll even change his mind if he's given this discovery and he's shown that Kohberger's phone was somewhere else, right? If that phone was at 1122 King Road, he'll change his mind. He'll change his testimony. He doesn't care. He's not going to ruin his reputation for Kohberger.
Yeah.
That's not what it's about. He wants to see the actual data. So he's missing records. He's missing that AT&T cell tower data. He's missing some phone records, some CDR records. He's missing some JSON file or something like that. I'm no expert in this. I am only listening to what he is asking for, and I know there have been 6 motions to compel. It was in motion 4, I believe, and motion 6, because it's been since he has been on the team that Ann Taylor has known exactly what to ask for. The most recent hearings, she has been very specific about, I need this, I need that, I need that. And I'm sure it's because he's come along and gone, I can't do my work unless I have these files.
Might help.
Yeah. So, I mean, he's a get, obviously. And I'm sure the state is like, damn it, I wish we had him.
Yeah.
And I know that, like Ghost pointed out, there has been one case where he hasn't been allowed in as an expert, but he has testified in hundreds of cases. So it's very unlikely that he won't be allowed in. He's been allowed in at pretrial, obviously. I know that's he could still be let out.
Sure.
But I think it's very unlikely. Yeah. So here's the thing. I think all of this talk about his alibi just being garbage, I don't know. It's just, and Andrea has said this as well, like this wording that was used in his alibi document about being exonerated. That's really strong wording. That's very strong wording from Ann Taylor to be writing that wording along with the alibi, but then saying that the motion to compel, those documents need to be provided and they will exonerate him. That's a lot bigger wording than simply there'll be a motion to dismiss or found not guilty. Exonerating? Oh,
Yeah.
That's big. That's big.
Definitely.
And then for Ann Taylor, who is a very, very well respected defense attorney and death penalty qualified, one of the 2 death penalty qualified public defenders in Idaho, to stand up there in court and say Brian is innocent. Yeah. So, and it just to also, if we look very quickly at these comments here, hang on, at these comments here, plus, oops, wrong one. Hello. Comments. At least there are finally some deadlines set out. Hopefully everyone is able to meet them. Not fair to the victims' families to wait another year. Too bad Judge Boyce isn't on the case. Okay. Well, I mean, Judge Boyce, that's the Chad Daybell trial. That one went on for about 3-4 years, didn't it?
Yeah.
I think that lawyer likes to hear herself speak. She is so annoying.
Aw.
Money, 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 money for lawyers, staff, judge, etc. Probably millions.
It's kind of how it works, princess.
It's not about money.
Well,
No way an innocent person wants to sit in jail for another year, plus the 2 he's already been there, if he knows he's never going anywhere, so he doesn't care. Really? That's not what it's about, guys. Anyway, cool. Thank you for being here, everybody. I'm going to be putting out some shorter videos very soon about this. There'll be another hearing, I think, in a month. They have been put into more of a schedule now. They're more like monthly hearings. People watching this who are not so much into watching trials, and there are a lot of people out there who are interested in this case who are watching the hearings and keeping up with Kohberger, but aren't really trial watchers. They just don't understand that these things take time. And they also don't understand another point, and that is that trials are for the defendant. They're not for the victims. It's sad, and it sounds really harsh, but the sentencing phase is for the victims. The victim impact statements, that's for the victims. This part here is for the defendant. There's only one person who is there to get a fair trial, and that's Brian Kohberger. This is not their time. So we can have vigils, and we can send our thoughts and our prayers to the victims, but Brian Kohberger, the trial is for him. It's about whether or not he did this. So we need to remember that when we're in the courtroom, or when we're watching the court, that this is for him. It's Idaho versus Brian Kohberger. Simple as that. So Benjamin Gray, she sits too close. They must be in a relationship. You know what? There's actually a comment there about she angles herself away from him. What does that mean?
Yeah. Check private chat real quick.
Link. Yeah. Okay.
Nice.
All right. We're gonna get going. Thank you so much, guys. Yeah, absolutely. Rather it take a while than to get to trial, to make sure that they get the right guy. And that's the other thing people don't understand, is that if you just hurry this thing along and shove somebody into prison, give them the death penalty, obviously people don't just go straight into the death penalty and then get shot. That's not how it works. But it's a matter of, you can then appeal it, and then you end up having to do the whole thing again. So it's just unrealistic. It's just completely unrealistic to expect these things are just going to go bam, bam, bam so fast. It's silly. So, yeah. Thank you, guys. And the evidence isn't there. It isn't there. Absolutely. And I know I have been pretty heavy pro Kohberger, but I reserve the right to change my mind. I absolutely will change my mind if they can bring out some proper evidence against this man and he did this thing. It's a terrible crime. It's a bunch of horrible, horrible crimes. And for sure, I will change my mind. But I ain't seeing anything, and I'm seeing some pretty gross stuff going on. from the prosecution on this. Too many red flags, and they just keep coming. I don't like it. Do not like it. Yeah. All right. Let's go. Thank you very much, guys. It's Sunday for me, and I have to prepare Tuesday for days Sunday. Oh, guess what? Who's joining us tomorrow, guys? Guess what? We have a special guest. Future Mrs. Martin 2.0.
Yay.
FMM 2.0 is joining us tomorrow. Yay! How excitement. I know, right? Yes, Dina. Future Mrs. Martin. Sean's better half is joining us. Yay! I know. How cool is that? And yeah, I will have a look at that. Ronnie? I know, how cool. How cool. I can't wait. And thank you for being here, Stephen. Also, you're new, I think. Good to have you here. Cool. All right. I'll see you guys tomorrow.
Yes. See ya.
Bye.
Bye. Did I freeze?
What freeze?
Oh, no, it's my
Nothing's
browser.
frozen.
Never mind.
Nothing's frozen.
Well, I'm
Bye.
frozen. Bye.